Hello and welcome to episode 3 of Vidhi Vaani series. This is Aashi Jain, a third-year learner from Dharmashastra National Law University, Jabalpur. Today, we are honored to have with us Mr. Utkarsh Sonkar, sir, a distinguished former civil judge from Madhya Pradesh, whose vast experience and insights into judicial system will guide us throughout this session today. And being a gold medalist from a national law school, I think he is the best person to guide us throughout this session today. In this episode, the theme of our discussion is importance of procedure in criminal cases. So, basically, what is procedure? Procedure is basically a backbone of any criminal case. It lays down the framework for how investigation, trials, and appeals are to be conducted. Procedure ensures fairness, equality, justness of rights throughout the legal process, thus safeguarding both accused and victims. Over to you, sir. So, my first question to you is, so what is the importance of procedure in any criminal cases or any criminal thing?
Thank you, Aashi. First of all, this is a wonderful theme that you have selected for this particular discussion. Procedure becomes important because we are governed by a jurisprudence which upholds the rule of law. Procedure implies that there is a manner in which a particular process has to be conducted. The importance of procedure in criminal process emanates from the fact that in a crime, we say jurisprudentially that it is committed against the state. So when state proceeds against an individual, there is an unequal bargaining power at both the ends. The individual against whom the state is actually proceeding generally has absolutely nothing when compared to the state. That individual is facing the complete might of the state, and state is all powerful, almighty. So if today the state decides to go against you and there is no manner in which that procedure is to be conducted, your rights would never be protected because there would be nothing to safeguard you. So that's why in jurisprudential terms, we consider procedure as a shield against this very might of the state, which protects our rights and liberties. Recently, you would have seen our very own High Court has recommended that the police officers should wear body cams. The reason and rationale behind that is the same, that compliance of procedure must be upheld and demonstrated in a court, because in courts, the inquiries that are conducted on facts and evidences that are brought before the court, passing through the muster of this particular procedure. So the inquiry becomes that of procedural truth, and that is the fundamental importance of procedure in a criminal process.
Oh my God, that was brainstorming, sir. So can you please give us a brief introduction, difference between criminal and civil procedures?
Yes. Procedures are virtually creatures of a statute. There are certain fundamentals that have to be complied with, like principles of natural justice. So we have 3 fundamental principles of natural justice. That is right to fair hearing, audi alteram partem, speaking order, that is any order must be reasoned, and nemo juris causa sua, that is no one can be a judge in their own case. These fundamental principles pierce through the entirety of procedure on both the civil and the criminal side. However, that being said, the procedure, as we have just discussed on the criminal side, virtually acts as a shield against the might of the state because of the unequal bargaining power between the two entities in that litigation. A criminal matter is taken up by state and it is prosecuting an individual. That does not happen on the civil side of things, where generally 2 private parties are sparring with each other. Therefore, the importance of procedure becomes much more pronounced on the criminal side.
Thank you, sir. So can you please give us any examples so that we can get some more insights from you?
Certainly. One of the greatest examples of upholding the law of procedure can be traced back to the case of Agnu Nagesha versus State of Bihar, wherein this particular accused person ended up murdering 4 individuals who were close family members. And after committing the act, he had a sense of realization and this person went to the police station, confessed to his crimes, and whatever statements he gave there were recorded in the FIR verbatim. That formed the bedrock of the FIR. Investigative formalities were completed. Thereafter, the person was charge sheeted. He suffered convictions at the district court level and the high court level. But when the matter travelled to the Honorable Supreme Court, the only question before the court was whether the FIR can even be read against Agnu Nageshi in that particular case. Because Section 25 of the Indian Evidence Act says that any confession given by an accused in police custody cannot be utilized against that particular accused. And the statement which Agnu Nageshi gave in this particular case, which was a confessional statement to a police officer, was virtually the FIR that was recorded in the case. So on this sole ground, in this case of gruesome murder, wherein Agnu Nageshi killed 4 of his close family members, he was acquitted by the Honorable Supreme Court eventually after a long-drawn battle. So this highlights the importance of procedure. And this is not to say that an accused can be let off in a particular matter. Like in Agnu Nageshi's case, the entire idea was that because confessional statement of the accused formed the FIR itself, it could not be read against him. The simple way to could have overcome this particular issue would have been recording of the statement of Agnu Nageshi before a magistrate, with the due safeguards which are provided for in the procedure, which would have resulted in his conviction. So law of procedure operates both ways. Yes, it definitely acts as a shield for the accused, but compliance with due procedure ends up helping the prosecution establish its case on the requisite threshold that is beyond reasonable doubt in criminal matters.
Thank you, sir, for sharing your insights. So my next question to you is, so what are the prominent procedural protection given to the accused?
So in the criminal process in India, Aashi, you would see there are various procedural safeguards. The most important one would be when liberty of any individual is to be curtailed. That is the provision of arrest. So you would see that whenever an accused is arrested in our country, he cannot be kept for more than 24 hours in the custody of the police without getting his custody endorsed from a judicial magistrate. So that is one procedural safeguard in his favor. Another procedural safeguard is that medical examination of the accused is done the moment they are arrested to ensure that they are not subjected to inhuman treatments in police custody. Another procedural safeguard is intimation to their families. And our criminal procedure has detailed prescriptions on these particular procedures which are there for the benefit of the accused. Similarly, there are other provisions, like we were discussing the case of Agnu Nageshi. So let's take an example from there. Regarding recording of confessions. So we discussed that had Agnu Nageshi's confession been recorded before a judicial magistrate, he could have been convicted in the case. Now our procedure has inbuilt safeguards even in recording of confessions of the accused. The provisions are quite detailed. They say that a summary inquiry has to be conducted to see as to whether the confession to be recorded of the accused is willful in nature or not. Because generally, accused is coming from the custody of the police in such matters whenever his confession is sought to be recorded, because this is something that happens in the formative stages of the investigation. Now our procedure prescribes that in case of denial of an accused for recording of his confessional statement, his custody cannot be authorized with the police anymore immediately.
Okay.
So the difference between two types of custody in our criminal procedure is, one is called police custody, one is called judicial custody. The simple distinction between the two is, the former police custody virtually implies that you remain in custody of the police, that is in the police lockup. Whereas in the latter, that is judicial custody, you are in the prison. So say for instance, an accused is coming in a court of law and an application is moved that his confessional statement has to be recorded. And if he refuses in the court of law to actually give a confessional statement, then law mandates that you do not authorize a police custody, because you can't send the accused back to the police in those circumstances, because there's an apprehension that he might be beaten black and blue after that. So there are various safeguards throughout the procedural laws that have been provided to safeguard the interest of the accused.
Sir, now that you have given us a good insight about procedural protection during investigation stage, now can you please give us a brief about procedural protection during a trial stage also?
Oh, certainly. So a trial in a criminal process, Aashi, begins when charges are framed by a court of law.
Yes.
A framing of charge in jurisprudential sense we understand is as saying formal accusation against an accused. So till now, perhaps the entire world was accusing an individual of something, but at the stage of framing of charges, a judge formally tells the accused that yes, I have found on prima facie determination that you have committed this particular offense and now I will be trying you for the same.
Yes, sir.
That is, state will be called upon to justify as to whether there are sufficient grounds which will breach the threshold of beyond reasonable doubt. The determination at prima facie level has happened at the level of charge. Procedural prescriptions are really important even at the trial stage. So even at the stage of framing of charges, you would see a charge has to be read and explained to the accused, because an accused should know exactly the trial that he would be facing so that he can be ready for his defense eventually. The second aspect during the stage of trial would be confronting the accused with whatever has been deposed against the accused by the prosecution. So in the erstwhile CRPC, we had a provision, section 313, wherein statements of the accused was recorded basically after the prosecution evidence was over,
Yes.
wherein all the incriminating evidence that has been deposed against the accused was put to the accused, asking his comments on those particular statements which have been made against him. So that is one of the most fundamental protections that has been offered to the accused. Now, at the same time, law is also cognizant of the fact that constitutional protections of the accused do not get diluted. So Article 20 of the Constitution of India provides to the accused right against self-incrimination. So though the accused is confronted with whatever has been said against him by the prosecution witnesses, you never force the accused to say anything positively. So for instance, when it comes to the stage of leading defense evidence, even if the accused wants to lead evidence, he has to first take permission from the court,
Yes.
so as to keep in mind his right against self-incrimination. So these procedural safeguards are present throughout the investigative process, the stage of inquiry, as well as the stage of trial.
Okay, sir, that was really insightful. So my next question to you is, can procedural fairness ever be compromised in the name of national security?
That's an extremely interesting question. And that takes me back to bomb ticking theory, wherein it is essentially said that there may be eventualities wherein to avoid a catastrophe, you would have to sideline all of the procedure that has to be involved in a particular matter. I personally do not subscribe to that theory, though I won't completely set it aside, because as I said earlier, procedure is the only thing which is protecting the accused against the might of the state. And once you remove that procedure, rule of law becomes compromised. It would virtually be a society without rule of law. Perhaps something that you have watched in Game of Thrones, that the mother of dragon can just fly by and say the magic words and the dragon will devour the particular individual. But we live in a society of rule of law. Hence, procedural safeguards are essential.
Sir, this question is very personal. Sir, I am very curious to know, why did you quit? You had been a civil judge for more than 3 years. Then what is the reason?
Thanks for that question, and that is a question which follows me everywhere. Even today when I meet people, the first question they ask me is, why did I quit judiciary? It was an extremely personal choice for me. I had seen the system closely thanks to my parents who have served in the district judiciary in Madhya Pradesh, and both of them have retired as principal district judges. I was following their footsteps, and that was my prime motivation for writing judicial services. However, during my time at law school and my internships that I did, I was really thrilled by the litigation aspect, the courtroom craft, and I have since been extremely passionate about it. So even prior to entering into the services, I knew that I would not be continuing for long. But in retrospect, I'm extremely grateful because the kind of experience that I have garnered during my days of judgeship is invaluable. And that is certainly something that I will cherish for the rest of my life.
Sir, we really look up to you, sir. Sir, during your days at judgeship, can you please strike out any example which serves our sub-theme for the day?
Certainly, Aashi. As a judge, I adjudicated upon a lot of criminal matters, particularly those dealing with Arms Act, wherein certain weapons are seized from possession of an accused person. Now, you would see most of the time when Arms Act matters are registered, a tip is received to the police that at a particular place, someone is in possession of an illegal arm. And generally, the police may be patrolling at this particular point of time. So what the police virtually does is that they go to the spot. If they find the accused in possession of a weapon, they immediately seize it, arrest the accused, come back to the police station and then register the FIR and move forward with the procedural formalities after that and complete the investigative formalities. In one of my cases, I saw that the seizure memo, which pertained to seizure of a pistol in a particular case, it had the crime number mentioned on that particular form. Now, crime number is basically the number of the FIR. Now, as we just discussed, in this nature of case, FIR is something which gets registered pursuant to seizure of the weapon.
Yeah.
So there is no way that a seizure memo can actually have an FIR number. It becomes unfathomable. So this demonstrates to you that perhaps this seizure was recorded after registration of the FIR. Now, if the offense that an accused is charged against is solely for possession of a particular weapon, seizure becomes crucial. And if the document which is endorsing seizure of a particular weapon on a person has a crime number which can be generated only after registration of an FIR, which did not happen at that point of time, it clearly shows to you that that document was penned down at a later point of time. So in these particular cases, procedure becomes of paramount importance. Just by the fact that crime number was written on a seizure memo is a ground good enough to acquit the person of an offense under the Arms Act provisions.
So this actually gave me a new perspective towards procedure things. So as we come to end of this insightful conversation, I wish to express my heartfelt gratitude towards Utkarsh sir for joining us today. His insights with respect to procedure thing has provided new insights to the listeners over there. Thank you for joining us, everyone, and stay tuned for upcoming podcast. Thank you.
Thank you.